rise. Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. Good morning, everyone. This is the time for oral argument in Brown & Brown Insurance of Arizona versus Mark New et al. It's our cause number CV230327. Counsel, I would remind you that we are recording these proceedings. So as you approach the podium, if you would please announce your name and which party you represent. The appellant is afforded, well, both sides are afforded 20 minutes. Appellant, if you'd like to reserve any amount of your time for rebuttal, you may do so, but you're responsible for keeping track of that.
So I'd like to reserve 4 minutes. When I get to 16, am I supposed to just sit down?
You get 20 minutes, so if you get to 16 and you don't sit down, the clock keeps ticking and you're not saving any more time for rebuttal.
Thank you.
And with that in mind, counsel, you may begin.
Thank you, Your Honor. May it please the court, my name is James V. I am counsel for appellants Mark New and Zach Hope, who sit behind me to your right. I would like to address 10 points here in my 16 minutes, so I'm going to hustle. There will be a brief introduction, a review of damages, a discussion of President Scott Jones' testimony, a discussion of Kevin Day and Michael New, who examined the equipment, the Dropbox, the witness's testimony, the contracts, punitive damages, and the claim for attorney's fees. So I'm going to go fast and I will sit down in 16 minutes. This is a case where Brown & Brown Insurance of Arizona sued 2 of its employees for setting up a new insurance brokerage. Without being able to show any damages or any solicitation of business from former clients, plaintiffs recovered a total judgment in the amount of $1,708,290. There was no evidence to support the compensatory damages claim at all. Punitive damages, exemplary damages, and sanctions should not have been awarded. Finally, the excessive claim for attorney's fees for a 6-day bench trial in the amount of $491,510 was not supported by any of the documentary evidence which normally attend a claim for attorney's fees, particularly a large one. Plaintiffs' refusal to provide the documents on which their claim for attorney's fees was based meant that the claim for attorney's fees could not be.
Counsel, wasn't there evidence that your clients did solicit at least some of the business after they were terminated?
I think they did not, Your Honor. I understand the
No, my question is whether there was any evidence of that.
I think the answer is no. They never called
A complete absence of evidence.
They never called a single witness who testified that he was solicited. My clients.
Didn't they have emails?
I'm sorry?
Didn't they have emails?
They did have emails, yes.
Okay, so there was some evidence. Emails are evidence.
Purportedly there was, but they didn't.
No, there either was or there wasn't. If there were emails, there were evidence.
All
so
right.
your statement that there was no evidence would be wrong.
All right, Your Honor. There were no.
And Mr. V, that kind of brings up an issue that, in reading your briefing, and if you're acknowledging there was evidence, and I understand your argument would be that the court got it wrong in how it looked at the evidence, how it concluded, made findings about the evidence, but what's our standard of review here when we're looking at a bench trial where the fact finder has heard your arguments, which I assume we're going to hear, we saw more about today in the briefing, we're going to hear more about an oral argument, but there's no indication that the court didn't hear an argument. They heard everything. They heard the evidence, they heard your spin on it, they heard Appleby's spin on it, and made a determination. So what's our standard of review for saying that the court got it wrong, and where are we seeing any kind of abuse in those decisions?
There are two issues here. The Court of Appeals reviews de novo for the interpretation of contracts. Second, the Court of Appeals will reverse a superior court's factual findings if they are clearly erroneous, and we believe they are.
And what's your evidence of erroneous versus just not going the way that you wish the court would have? And
I have a list of them here, Your Honor.
okay.
The trial court awarded damages when there was no evidence of damages. Awarding damages based solely on Exhibit 78. Mr. Jones was the
And
president.
counsel, just from my recollection, when you were saying Exhibit 78, you're referring to the document that was prepared by your clients.
It was a document that Mark New typed out in his computer for his own purposes. It wasn't based upon historical earnings. It was just a projection of what they might do.
And did you cross-examine Mr. Jones on that issue at trial?
I did indeed.
Okay, and so the court again heard what your take on that was and why it shouldn't be considered.
Mr. Jones agreed. What I can tell you is he didn't know where the document came from. He didn't know who prepared it. He didn't know if it was reliable. And that was the sole basis for his testimony, which he also agreed was speculative.
But you just told us you know that your client prepared it, correct?
My client prepared a document for himself.
Right, but I'm saying that was Exhibit 78, so
Yes.
you know the nature, and you and Appleby's were able to cross-examine your client on what the basis of making that document was and what was and wasn't included and that sort of thing. So the court, again, heard all of that, correct?
Yes.
Okay.
The witness, Scott Jones, testified he had no idea who prepared the document. He had no idea if it was reliable. He had no idea where it came from, and he finally conceded his testimony was very speculative.
But the court heard testimony that Brown & Brown did not receive commission it would have received had the defendants placed the accounts with Brown & Brown. Isn't that correct?
They made such claims.
Well, that's what the court heard, that there are commissions that would have gone to Brown & Brown but did not, but for the behavior of your clients.
The first judge in this case, Judge Viola, ruled that if customers who had been customers of my clients when they worked at Brown & Brown called them up and asked them to work for them in the future, that was permissible because customers can decide who they want to provide insurance for. And that happened, and we had 7 such people come to trial and testify, and we have named them. Those 7 people were customers of Brown & Brown. That's where my clients met them. But when they heard that my clients were fired, they all called them up and said, we'd like to put our insurance business with you.
Wasn't there evidence that your clients actually contacted them almost immediately after they were fired?
There were they had some ongoing deals and meetings arranged, and there were discussions about that kind of thing. But all of those people thereafter called my clients and said, we want you to do our insurance business.
But the court did hear evidence that your clients contacted Brown & Brown's clients immediately after being terminated from their employment.
Yes.
I'm not asking you to agree as to how the court should have interpreted that evidence, but I'm asking you, did the court hear that evidence?
There were a few cases like that, but it didn't relate to soliciting business. It related to the fact they already had ongoing meetings planned, stuff like that.
And Brown & Brown's position was that it was not related to ongoing meetings, or if it was related to ongoing meetings, it was related to improper solicitation, and it was completely contrary to your position, right?
Yes, my clients said that is not what happened.
And Brown & Brown says that is exactly what happened.
Well, the problem with
Right?
that is, once again, Your Honor, Brown & Brown never called a single witness
No,
to
but
testify about
let's
that.
stick with that point for just a second. Brown & Brown says that is exactly what happened. Your clients called, they started down the list as soon as they were terminated, right? That's their position.
That is what Brown & Brown's lawyer said.
Okay, and the court believed their position more than it did your client's position.
I think so. But I think in the
So
end,
now we're back to the standard of review, and where are we in terms of reviewing the court's factual determinations?
I understand. I do have a few other issues about mistakes. They allowed Mr. Day to testify that 200,000 files were deleted when it was clear that neither Mr. Day nor Mr. Kunkel had looked into the Dropbox. They had no idea.
Did your client, it was interesting to me that the Dropbox was mentioned, but couldn't your client have produced, I mean, they knew what the disclosure was asking for, and if the people who were tasked with finding those documents because they hadn't been turned over, couldn't your client just have disclosed the contents of the Dropbox? I'm having trouble understanding, and maybe I missed something, which is why I'm asking, is that to say we didn't disclose something and then on the stand saying, well, you just didn't look in the right place, to me, it feels like an obligation of your client to disclose and then to come at trial and say, well, we've had them all along, all they had to do was look in our Dropbox. Help me understand why that's a consistent position.
They got my client's Surface Pros, those are little laptops.
Right.
And they clearly had Dropboxes, both Mr. Day and...
But you're missing my question. I understand that your client knew that. I mean, that was the testimony is, well, you just didn't look in the right place. We had these Dropboxes. Did you look there? No, we didn't look there. Well, if you would have looked there, you would have seen this trove of information which you've been seeking the whole time. So if that was the case, wasn't your client free to turn over and disclose everything in the Dropbox before, during, or after the forensic examination, but prior to trial?
These devices disclosed right on their face that there was a Dropbox, and both gentlemen knew that was...
You didn't answer a question. She really asked you a yes or no question. Your clients had an obligation to disclose this before, during, or after the forensic examination. Did they abide by their obligation to disclose it?
It was disclosed when you open up these laptops. It says right there, there's a Dropbox. Mr. Kunkel noted that the Dropbox was full.
So you're telling me that when the rules of discovery say you have to disclose something, it's enough if you just say, oh, it's in my Dropbox?
Well, I don't think it crossed my client's mind they wouldn't look at it. The very front of the face of the computer says there's a Dropbox here, and Mr. Kunkel knew it was full.
But Judge Bailey just asked you, and I think it's a legitimate question, is if the obligation was to disclose whether it was in the Dropbox or not in the Dropbox, it was still your client's obligation to disclose the information. And they didn't disclose it.
I think my clients thought they did disclose it, Your Honor, because
Well, isn't that why they had a forensic examination? Is because they couldn't get your clients to disclose information, and so the court went through the whole process of getting you guys to agree to an examiner, you turn over all the information, but if it was there from the beginning, a forensic examiner wouldn't have needed to be appointed if it had been disclosed. I'm just confused about that.
Well, as a matter of fact, there was a big issue about the examiner.
No, I know that, and that's a different issue. Back to the question of if it was there all along and your clients knew it and they knew where it was, which is what you're saying, it was all in the Dropbox, and they'd been asked to disclose it, you wouldn't have needed a forensic examiner if they had just emptied the Dropbox when asked to disclose the documents. Is that an incorrect statement?
I am not a computer expert myself. I don't want to speculate about things. I can tell you my clients just assumed it said right on the front, this is the Dropbox, and it's full. And it never crossed my client's mind they wouldn't look. These were not stupid people. These were people that held them out as experts with respect to computer technology. And I think they got the stuff, and we presumed they made copies of everything. And in fact, neither Mr. Kunkel nor Mr. Day chose to look at the Dropbox, which was right there. That we hadn't even thought about that.
Okay.
Other things that we thought were offensive were awarding punitive damages without any evidence of actual damages at trial. Second, awarding punitive damages in a size that will kill the defendants without plaintiffs obtaining any evidence of the defendant's net worth. The judge decided to award punitive damages, but nobody ever asked these people, what is your net worth? And they are people with very modest net worths. Finally, awarding $491,500 for a 6-day bench trial in attorney's fees. I sent out a subpoena to ask for the documents on which that claim was based, and opposing counsel refused to give the documents to me. And I never got them. And it's very difficult to impeach or question a claim for attorney's fees when you are denied all of the documents on which that claim was made. I think I better stop now at 5:57 and have 5:57 for my rebuttal.
All right, thank you, counsel. Let's hear now from Brown & Brown Insurance.
Good morning, Your Honors. May it please the Court, David Norris for Brown & Brown Insurance of Arizona. As this panel has already noted, this case is on appeal from a 6-day bench trial during which 12 witnesses testified and over 100 documents, exhibits were admitted into evidence. Following that trial, Judge Agni held that there was overwhelming and incontrovertible evidence of appellants' breaches of their common law, their statutory, and their contractual duties. She found that those breaches had caused $521,000 in damages based on lost commissions on 14 specific accounts that were either diverted to the competing company or solicited from Brown & Brown in breach of appellant's duties. And she set forth those factual findings and the specific evidence that she relied on for those factual findings in her detailed 30-page, 160-paragraph findings of fact and conclusions of law. Those findings of fact are supported by reasonable evidence, and they should be affirmed in a normal case. But this is not a normal case. 2 days before the appellants turned over their devices to a forensic examiner, the forensic examiner that was only required because appellants had previously been caught failing to comply with discovery, appellants ran anti-forensic software to wipe beyond recovery over 200,000 files and 400 text messages. And so the 2 points that I have this morning are that the appellants did not and cannot show that Judge Viola abused her discretion in entering an adverse inference as a result of this intentional destruction of evidence. And then the second point is that the evidence presented at trial or the adverse inference, each independently on their own, are sufficient to affirm all of the factual findings and as a result the entire judgment. So the first point, this came up a bit about whether there was evidence that documents were destroyed. And I'll tell you the evidence is overwhelming. So just a few of the key facts. Appellants voluntarily did not produce a single document about what they were doing with their competing insurance company while they were employed by Brown & Brown. Not one. We subpoenaed third parties produced those documents. And this goes to the point that Judge McMurray and Judge Bailey, you were asking about, is if this information was on the Dropbox the entire time, they had an obligation to produce that information voluntarily instead of us subpoenaing it from third parties, finding out that they hadn't produced it. And then that's what necessitated, the forensic examination. That was found after an all-day evidentiary hearing on our preliminary injunction and the failure to produce relevant documents. Judge Viola held that they had failed to produce and comply with discovery. That's why the forensic examination was ordered. That ruling is not on appeal. They don't appeal that ruling or the appointment of the forensic examiner. Then, 2 days before turning their devices over to the forensic examiner, both appellants ran anti-forensic software called CCleaner. They admitted that they didn't just run CCleaner, they ran a non-default version of CCleaner called Wipe Free Space. And the purpose of Wipe Free Space, if you look on the CCleaner website, which the testimony at the sanctions hearing was, appellants did research this specific page, researched it was their testimony before running the feature. The purpose is, it says that if someone has the right software, they can recover deleted files. Wipe Free Space ensures that, quote, deleted files can never be recovered. That's Exhibit 42 to the spoliation hearing. And the feature worked as advertised. As a result, over 200,000 files were wiped beyond forensic recovery. And everything I just mentioned That's just the undisputed facts at the forensic examination hearing. And based on those undisputed facts, failure to produce documents, running anti-forensic software 2 days before turning it over, there's no abuse of discretion for ordering an adverse inference. Rule 37 provides broad discretion to trial judges on discovery issues like this, including with respect to intentional deletion of evidence, ordering an adverse inference, fee shifting, or ordering default judgment. And I'd say in Berg v. Weiss, this court recently, Judge Cruz, you were on the panel in that case, affirmed default judgment. Default judgment on similar facts, although there was no anti-forensic software in that case, but similar facts where there was spoliation of evidence mid-litigation. The site for Berg v. Weiss is 2020 Westlaw 208-6477. Affirm default judgment because that is such, I mean, it goes to the heart of discovery when you intentionally destroy and wipe documents in the middle of litigation. We cited in the papers below a number of cases where default judgment was affirmed for using CCleaner in the middle of litigation. And so the point of all that is Judge Viola didn't abuse her discretion in ordering the lesser sanction here of an adverse inference. I want to cover just briefly a couple of the...
Before you move on, what about the Dropbox?
Sure.
Could you explain to me, was it ever was the materials in the Dropbox ever produced?
Well, the documents were not voluntarily produced by the appellants, so that's true. It's not true that the forensic examiner never looked at the Dropbox. The forensic examiner absolutely looked at the Dropbox. What the forensic examiner could not do, because it's impossible, is determine whether the files that were deleted using anti-forensic software were in the Dropbox, because you can't compare what you don't know what it is because it's been wiped to oblivion to what remains. But there are a number of, bases that Judge Viola looked at when she, determined that she didn't believe this excuse that everything was just in the Dropbox. And here's a couple of them, not all of them. The first is the Dropbox testimony wasn't even the primary excuse that was offered at the spoliation hearing. The primary excuse was, well, we had computer problems 2 days before. And Judge Viola said, well, that's not very believable that both of you had computer problems and CCleaner prompted you to run it 2 days before turning over your devices. She said that excuse strained credulity. That's at IOR 162 at the 154. The other is that they testified their typical practice was, well, let's take everything that's relevant, let's put it up in Dropbox, and then we'll run CCleaner. And the problem with that is the undisputed testimony at the hearing was they'd only run this anti-forensic feature once, 2 days before turning over their devices. This was not part of some typical practice. The other is they said that, well, we put everything that was relevant into Dropbox, and if it was relevant, we produced it. And as we discussed earlier, the whole reason there was a forensic examination in the first place was the finding that they had not complied with discovery and had not produced all relevant evidence. And so for all of those reasons, Judge Viola said that the appellants, they lacked candor, and that the coincidences in this case are too great to ignore. And that credibility determination, as the panel well knows, is not something that can be overturned by an appellate court on appeal. So that brings me to my second point, which is that with the adverse inference or without it, take the evidence or the adverse inference, either one of them alone are sufficient to affirm the entire judgment. And before getting into the evidence, I want to talk briefly about basically the only legal issue or one of the only legal issues that is at issue on this appeal, which is the contracts. And Mr. V said that those are reviewed de novo. That's true. And their arguments are contrary to law. And Judge Whitten and Judge Viola and Judge Agni all rejected all the legal arguments they make about the contracts. And I'm happy to talk about any of those that the panel has questions about. But the other key point is you don't even need to find that the contracts are enforceable to affirm the entire judgment. All of the damages in this case are independently supported by other claims that Brown & Brown has. And so I'll just give you there's two big categories. There's the clients that were diverted to the competing business while appellants were employees of Brown & Brown. And then there are the clients that were solicited to their competing business after they were fired. So for the accounts that were diverted, either you can rely on the contractual duty of loyalty, it's a breach of that, but there's also a common law fiduciary duty of loyalty. And so you don't need the contracts to affirm all the damages for the 7 accounts that were diverted to the competing company while they were employees. On the accounts that were solicited after the appellants were fired, we have a common law unfair competition claim. and we have a statutory Arizona Uniform Trade Secret Acts claim because appellants took our confidential and trade secret client list information and used that, as Judge Cruz said, to run down the list and figure out who to call, exactly when to call, and what information to use to undercut the pricing and the products we were offering to solicit that business. So again, you don't need the contracts to affirm all of the damages awarded with those specific accounts. And so the point is, appellants have to overturn on appeal the factual findings. The factual findings by Judge Viola after the 6-day bench trial, if they want to overturn the judgment, and based on the standard of review, that's not possible. That standard of review is clearly erroneous. That means that all Judge Ogney needed was some reasonable evidence in the light most favorable to supporting the judgment and the findings, just reasonable evidence of the breaches. And so this was covered in detail at the trial. It's covered in detail in the findings of fact. I can't possibly go through all of it, but let's talk about some of that reasonable evidence. On the loyalty piece, the breach of the duty of loyalty, the evidence was appellants created a competing company named Dorado while they were employed by receiving 6-figure salaries from Brown & Brown. We were paying for their marketing expenses, sending them leads, referrals. Their stated goal in text messages between one another, their stated goal was that they wanted to attract good talent to Dorado and grow it to $10 million in revenue. One of the appellants was the manager of Brown & Brown's employee benefits division at this time. His job responsibilities was to attract good talent to Brown & Brown, to grow Brown & Brown's division, not to do that for his competing company. They testified, this was actually during whether the question was whether there should be the sanction, again at trial, but this first came out whether they produced all relevant evidence. And they said the reason we don't have any evidence of what we're doing at Dorado, this competing company, is because we didn't do anything for Dorado, and if we did anything, it was just to help one of the appellant's dad, Bob Hope. Everything we did for Dorado was to help Bob Hope. Well, at the same time they were testifying to that, they didn't produce this document, but eventually out of the forensic examination, we got Exhibit 1 at trial, which was a email where they said, actually, we're running Dorado, and we're just, quote, using Bob's name as cover, smiley face. That's Exhibit 1 at trial. And so the 7 accounts that were placed at Dorado, there's a spreadsheet. This was Exhibit 78 that was discussed previously. That spreadsheet listed who the broker on all those accounts were that were diverted to Dorado while they were employees. And either one of the appellants, not Bob Hope, either one of the appellants was listed as the broker for all of those accounts. Just some of the information. On confidential information, appellants emailed Brown & Brown's trade secret and confidential client lists from their Brown & Brown email addresses to their Dorado email addresses while they were employees of Brown & Brown. That's Exhibit 151 at trial. We also found there this list again. Appellants had stamped it as confidential, their client list. They had claimed during the proceedings it was a trade secret. In a prior discovery dispute, they said, well, we don't have to produce our client list. Those are trade secrets. And if you looked at it, it was comprised of a disproportionate number of Brown & Brown clients, despite the fact that any company in Arizona with more than one employee could be a target of an employee benefits broker. Not the majority, but a disproportionate number of the accounts on that were Brown & Brown accounts with things like when the account was coming up for renewal, who the contact or the key decision maker was. On solicitation, Mr. V said that at one point said that there was no evidence that there was solicitation. But we have text messages between the appellants obtained through the forensic examination about striking while the iron is hot on Brown & Brown's groups and putting Brown & Brown's groups on their list. We've talked about it a decent amount already this morning. It came up a lot at trial. We found that list again. This was Exhibit 78 at trial. This had the disproportionate number of Brown & Brown accounts on that list. We have their call logs, which had outbound calls to all of the accounts we're talking about. I think with the exception of one, we have outbound calls to the people who were solicited. In some cases, as many as 49 outbound calls from the time they were fired till the time they won that account for their competing business. And then we also have emails where the appellants emailed the client and said, stop talking to Brown & Brown and send me the BOR letter. That's Exhibit 108. And the BOR letter in this industry is the letter that assigns an account from one company to another company. So literally, it's an email saying, stop talking to Brown & Brown and give me your business. On damages, this came up during Mr. V's, the questioning of Mr. V. We have appellant's own spreadsheet listing the damages, listing the commissions that they were earning on each account. And so again, this is just the evidence, overwhelming and incontrovertible evidence that Judge Ogney found that was presented at trial. all of that alone is independently sufficient to affirm the judgment, but on top of that, we have an adverse inference that damaging information was destroyed. And the point I'd say is even if we didn't have all of this overwhelming evidence, the adverse inference alone would be sufficient to affirm the judgment. And one of the reasons we know that is because that's exactly what Judge Viola held at the trial court. After the adverse inference was entered, appellants had 4 partial motions for summary judgment that were pending. Judge Viola denied all of them because she said, well, there's a reasonable basis for a trier of fact to find in favor of Brown and Brown on every single claim because of the adverse inference. And that's IOR 198. So,
Mr. Norris, I assume, as I asked Mr. V, that because your witness didn't produce Exhibit 78, that you certainly, I didn't candidly read the interaction at trial between you and, was it Mr. New, who did create the document? I mean, I assume that there was some foundation laid for what Exhibit 78 was and how it was created and where the information came from.
that's exactly correct. Judge Bailey, the testimony at trial was that, by the appellants, was that Exhibit 78 was created because they wanted to track the commissions that they expected to receive from insurance carriers. So they created Exhibit 78 to make sure that they were getting paid the correct amount of money. And not only do we have Exhibit 78, we then have Exhibit 79 and Exhibit 80, which were monthly follow-ons from this, where they updated, as they got additional information, they updated the commissions. And sometimes the updates were as little as 5%, small tweaks to the amount of commissions that they were receiving. And I'll tell you, the other is that the claim that Exhibit 78 was the only piece of evidence that was relied on isn't true. So we have a problem with accounts that were diverted from Brown & Brown to Dorado because we don't have any data on what they were never Brown & Brown accounts, and so we don't know what the commissions were. So we have to rely on appellants' documents to estimate that. But for accounts that were solicited from Brown & Brown, we do have some of that data. And so what Mr. Jones did was he compared, for those accounts, he compared the commissions that the appellants had set forth on Exhibit 78 and Exhibit 79 and Exhibit 80, and he compared that to Brown & Brown's internal figures on what the damages were, or what the commissions were. That's Exhibit 136 at trial. It's at App 2 154. And so there's ample evidence that these were, reliable figures. I mean, just another example, 8036, the business record exception, it exists for this exact purpose. Business records, you have a reliable, a hearsay exception because you have a reliable reason to rely on those business records because you have every incentive in the business to get those right. You have every incentive when you're the appellants to get the commissions you expect to receive correct, so you know that you're getting paid the right amount of money from the carriers. And so just on this point, the other point that Mr. V raised was that there was no evidence that this activity caused any damages to Brown & Brown. The evidence is, it's just very simple. Brown & Brown earns commissions on the accounts that it has. So when a account is diverted from Brown & Brown to their competing agency, it's never placed at Brown & Brown, and it would have been placed at Brown & Brown had they complied with their duty of loyalty. We lose the commissions on that account. When an account is solicited from Brown & Brown in breach of their contractual duties or because they're using our trade secret information to target our clients, we lose the commissions on those accounts. That's about as simple and straightforward and non-speculative and as quantifiable as damages ever come. And so that's why we basically have 7 specific accounts that were diverted while they were employees, 7 specific accounts, and based on the commissions for those accounts, the damages were calculated, and then we have 7 different accounts that were solicited after they were fired, and that's how those damages were calculated. One other point I would raise is Mr. V references that Mr. Jones supposedly admitted at trial that the damages were speculative. That's a mischaracterization of the record as well. What really happened is Mr. Jones testified that the average account stays at Brown & Brown for 7 years. So on average, you're going to earn 7 years in commissions from an account, but it's possible some accounts stay for decades. And what Mr. Jones testified is it would be speculative if we were claiming damages for decades and decades and decades of lost commissions. We're not. We're asking for 2 years of lost commissions. And the reason we're asking for 2 years of lost commissions is there's a 2-year covenant in this case, but also, more importantly, that's what accounts are bought and sold for on the marketplace as a floor. Usually they're actually bought and sold for 3 or 4. So we didn't take 3 or 4, we didn't take 7, we didn't take decades and decades of lost commission. We used the absolute most conservative estimate of what the damage is here, which is the 2 years of commissions because of the covenant or because of the market value of the accounts. And so I'm at a minute left. If there's any questions from the panel, I'm happy to answer them.
No, thank you.
Otherwise, we request that you affirm the judgment. Thank you, Your Honors.
Thank you.
All right. Thank you, Mr. Norris. Mr. V, you have your 5 minutes and 51 seconds to respond.
When Judge Viola issued her minute entry about an adverse inference, she was misinformed about the fact that there would be a jury trial, and she thought it was appropriate for her to instruct the jury that would hear this case with her idea of an adverse inference. In fact, the contract ruled out a jury trial, and it is not Arizona law that when the administration of the Superior Court sends a case from Judge Viola's division to a different division to be tried, that the subsequent judge is required to abide by the prior judge's adverse inference. She has to hear the evidence, conduct the trial, and make the decision herself. The adverse inference was specifically intended for a jury, and that's what it says when you read it. It was not appropriate when there isn't going to be a jury. During the trial, I asked Mr. Kunkel I asked Mr. Day, what did you find when you looked at the Dropbox? And he says, what do you mean? I said, do you know what a Dropbox is? He says, yes. Question, was there a Dropbox involved in these computers? Yes. Mr. News Dropbox? Yes. All right, did you look at it? Answer, I did not. And then skipping down, I never looked at the contents of the Dropbox. If there were thousands of files, you didn't see them? Answer, I did not personally see them. No. And the report he prepared with Mr. Kunkel didn't mention there was a Dropbox either, although they were both aware of it. They knew it was there, they didn't look at it, and they didn't open it, and they made no reference.
Well, not to keep beating a bad drum here, but the obligation is your client's to produce the evidence. It's not the obligation of the forensic scientist to look and find every conceivable place that it could be hidden. So the bottom line here is there was, even assuming all evidence was in the Dropbox, that doesn't alleviate your client's obligation to produce it.
Well, Your Honor, there was an icon on the screen that said Dropbox. They knew that Dropboxes were designed.
How does that alleviate your client's obligation to produce the documents?
I guess you and I have a different understanding. The order was to turn over your electronic equipment. They had two.
Well, the discovery rules would have required those documents to be turned over long before that.
Well, they turned them over, and it said right on the front, there's an icon that says Dropbox, and we assumed they looked at everything. These were not people that, these were people who made their living examining computers. That's what they did, and we thought they would do it. The second thing, despite the erasure, there were 120,000 files which survived, And of those, 30,000 were files that had terms of relevance to this litigation. So nobody could allege that they did a wash of the whole thing. There were 120,000 files left there, 30,000 of which had language in them that was thought to be relevant for this litigation. And I'd like to read you a little testimony from Mr. Kunkel about that. He was called to testify at an evidentiary hearing conducted by Judge Viola on May 6, 2021. And I asked him this question. You have told us today that 20,000 files and folder entries were deleted in 2020. Do I have that correct? Yes, deleted and wiped from Mark New's computer. Question, you have no information that those files have anything to do with this case, do you? Answer, that is correct. Question, you're kind of speculating that they had something to do with this, but you really don't know if it's true or not, do you? And he said, I wouldn't say that I was speculating. I don't think I ever said that I knew those 200,000 pertain to this case. Well, to make it short and save time, the truth is you have no idea if those 200,000 files had anything to do with this case or not. I do not. They never had anybody testify that those files were relevant. The uncontradicted evidence is that these guys had
How can
records.
someone testify they're relevant if they don't know what they are?
Well, the presumption is that my clients erased files that were related to this case. The uncontradicted evidence is that they say these files were medical records and financial records of clients that are protected by federal law. And we stored those in the cloud for the security of our customers. And nobody contradicted that. I got 3 seconds left. I think I will.
Thank you, counsel. All right, the matter is deemed submitted. We'll issue a decision in due course. Thank you very much for your briefing and your argument.
Thank you.